Good afternoon, Mr. Millar.
Good afternoon, Acting Chief Justice, members of the Commission.
Yes. How are you feeling this afternoon?
A little nervous. The waiting is
Has been too much.
It's not the easiest thing to do, but I'm here.
Yeah. Okay. Thank you for availing yourself for consideration for appointment as a judge of the Gauteng Division of the High Court. I see that you hold 2 degrees, BA and LLB. Is that correct?
That's correct.
You got your BA at the end of 90. You completed at the end of 1989. Is that right?
That's correct.
And you completed your LLB at the end of 1992.
Yes, sir.
And you were admitted as an attorney in 1995. Is that correct?
Correct.
And the law firm was Norman Berger Attorneys.
Correct.
Is that right?
Yes.
And you later became a partner and director, and that remains the position. That is from 2000. Is that correct?
Yes, Acting Chief Justice.
From June 2000.
Correct.
Up to now.
That's correct.
Yes. Can you please tell the commissioners about the types of cases that you have been doing as an attorney in your firm?
Yes. The firm, it was a general practice, so we dealt with quite a wide array of work. We were also notaries and conveyancers. I'm not a notary, my partner was a notary, but we did quite a fair amount of notarial work and conveyancing. And then the litigation that flowed from that work. We also dealt with matters relating to the less fortunate, so we did deal with, in many cases, road accident cases and medical negligence cases, and pretty much general litigation. And that was the scope of our practice and what we dealt with for most of the years. Once we started dealing with claims or cases relating to overreaching by attorneys and the application of the Contingency Fees Act, the position changed somewhat, and we then found ourselves dealing with far more matters of a forensic nature relating to overreaching, overcharging, attorneys' mandates, and so on. And so we developed a reputation for dealing with that kind of work, and that's been, or was for, I would say, probably the last 10 years, just under the last 10 years or so.
You don't have any publications to your name, isn't it?
That's correct, Chief.
Yes.
Acting Chief Justice.
And to the question, do you appear in court? You have answered occasionally, is that right?
That's correct.
And occasionally would be like once in how long?
It would depend on the nature of the matters. Sometimes unopposed motions, sometimes opposed motions.
Have you done any criminal trials during your period practice as an attorney?
Right at the beginning of my articles,
yeah.
The firm was on the Legal Aid Board. I don't think it was called the Legal Aid Board then, but it was Legal Aid South Africa, and we used to have work allocated to us by them, and I did have some experience in doing those matters. But that was at quite an early stage of my career. Once I'd qualified, I didn't deal with criminal matters. The firm didn't.
So is the position that you did those criminal matters while you were doing articles?
Correct.
Yes. Obviously, those couldn't have been serious criminal matters.
No, they weren't.
Doing candidate
the matters I appeared in on my own weren't particularly serious.
Yeah.
I did accompany counsel for a number of matters relating to murder and culpable homicide and things more serious than that. But I wasn't the appearer. I was the the instructing attorney in those matters.
It would be fair, would it not be, to say, really, for all intents and purposes, you don't have much criminal law experience?
Not in my practice as an attorney, but
yeah, as an attorney.
Yes, that's a fair statement.
Yes, and I see here in your answers to the questionnaire that in terms of administrative law, you have no experience at all.
That's correct.
And in terms of constitutional law, you have no experience at all as well. That's what you
yes,
answered here.
Yes, the firm didn't take instructions or get instructions in matters that were of that nature.
And in labor law, also, you said you have no experience at all.
Yes, we consulted clients on labor law matters, but not we didn't litigate in the labor court.
What areas of law do you have experience in?
Well, in property law, conveyancing, estates, customary law relating to estates and relating to aspects connected to that, personal injury law of various iterations, road accident matters, medical negligence matters. I do have extensive experience in the more forensic work relating to attorneys' costs and attorneys' practice and matters relating to fee agreements and the like.
You have put up one case, reported case, where you said you appeared in court. Is that right? Engelbrecht?
That's correct, Acting Chief Justice.
And then you put up about 12 cases where you say you were in the instructing attorney that have been reported.
Yes.
Is that correct?
Yes.
And I see that number 8 of those cases is Ronald Bobroff and Partners Incorporated versus De La Guerra, 2014, volume 3. Do you want to tell the commissioners a bit about what that case was about?
Yes. Acting Chief Justice, that was a case relating to the billing and the fee agreement that had been applied by the firm of attorneys, Ronald Bobroff and Partners, in respect of their client, Ms. De La Guerra. Ms. De La Guerra instructed us, she had concerns relating to the way in which she'd been billed. And once we investigated it, we ascertained that the fee agreement that had been applied by Mr. Bobroff, but it subsequently turned out that it was a practice that was carried out by many firms, was to use something that was called a common law contingency fee agreement. Now, I think we all know that there's no such thing as a common law contingency fee agreement, and the Contingency Fees Act made it very clear that the only way in which a contingency fee agreement could be entered into by a legal practitioner with their client was under the auspices and in compliance with the Act. So we initially attempted to resolve the matter with Mr. Bobroff, but he was unwilling to do so, and litigation ensued. And that litigation has really changed the legal landscape, I would submit, because once the full court found, and it was subsequently confirmed by the Constitutional Court, that there was in fact no such thing as a common law contingency fee agreement, and that attorneys and legal practitioners had to comply with the provisions of the Act, I think a lot of excesses were brought to light. And so that judgment was important because it set the boundaries, which I believe has resulted in a proper application of the law and savings to not only Ms. De La Guerra, but to possibly hundreds of thousands of other victims of road accidents who would have entered into such agreements. Yes. So an important point for private individuals who would be, in many cases, approaching attorneys for the first time.
Okay. Now, have you done trials in the High Court as an attorney on your own without counsel?
Not in the High Court on my own without counsel, no.
Yes. Have you done some as the instructing attorney with counsel?
Many with counsel,
Yes.
Acting Chief Justice.
Have you acted in the High Court?
I have, Acting Chief Justice.
How much acting time have you had?
I have a total of 76 weeks
Yes.
acting experience.
And did you do trials, motion court, and criminal appeals and civil appeals?
All of those things. I also appeared in the urgent court as well.
Yes. Are you familiar with the Plascon-Evans rule?
Yes, I am.
What does it entail?
Plascon-Evans rule relates to the weight or to be attached to evidence in motion proceedings on papers, and how the evidence on papers and the versions on papers is to be assessed in determining the matter on papers.
Yeah, but articulate it.
Well, as I understand it, if the applicant...
What circumstance must you see in the papers that must give rise to invoking this rule?
Yes, as I understand it, if the applicant makes an allegation and the respondent disputes that allegation and disputes it effectively on the basis that there is no reasonable prospect that the allegation can be sustained, then the version of the respondent must be preferred.
But if the respondent disputes it, simply disputes it, what happens?
Well, there's a simple dispute of an allegation has to be viewed in the totality of the papers. Often an explanation for the dispute can give guidance as to the nature of the dispute. A simple bald denial to avoid answering an allegation is of no assistance to the respondent.
Not a bare denial, but a denial nevertheless with whatever explanation.
Well,
how do you resolve that dispute?
If the explanation is substantiated in one or other form, then one would have to look at the substantiation and weigh it against what has been put forth by the applicant. And one really does that in the context of the entirety of the case. The facts in a case are really pieces in a puzzle, almost like fibers in a blanket, all woven together. One sees the whole, but one must also look at the individual components to see the veracity and the strength of those components. So that the process is to look at it as a whole. I would submit.
And if you are sitting in an appeal court dealing with an appeal and there are factual findings made by the lower court, under what circumstances can you as the appeal court interfere with the factual findings of the lower court?
Well, Acting Chief Justice, it depends on the nature of the findings. If the findings are substantiated by the other evidence, then there's no basis to interfere unless the findings are clearly wrong with regards to the evidence that was before the lower court. If the findings are made in regard to, for example, credibility and things that aren't readily and necessarily apparent from the record, then as an appeal court you would be far more circumspect in interfering with the lower court's findings on those aspects. And
when do you talk of a misdirection by a lower court when you are dealing with a judgment of a court?
Well, I think if a lower court doesn't apply itself correctly, apply the law correctly to the facts that are before it, it's misdirected itself. So the findings as to the facts may be correct, but the application of the law may not necessarily be the correct application in the context of that matter. So I would say that those would be circumstances where one would say that there was a misdirection.
Judge President Lam.
Thank you very much, Acting Chief Justice. Good evening, Mr. Millar.
Good evening, JP.
Thank you. I think just to fill up the gaps in terms of what the Acting Chief Justice asked you, I see that you did 9 weeks in the criminal trial courts. Is that correct?
That's correct, JP.
Yeah, but I suppose part of it was interrupted by COVID.
I had only one matter that was interrupted.
I see.
The term ended a few days after the
announcement.
the announcement of the state of emergency on the 27th of March, or when it became effective. So I didn't, in point of fact, my criminal trial that I was busy with was already going to be postponed because the accused was ill, and we weren't able to finish anyway. But we subsequently finished that trial during the July recess when he was able to come to court.
Yeah. In that criminal trial stint, how many trials did you finish?
JP, I think there were 3 matters that were finished in total. A number of matters there were postponements and various other interlocutory matters that arose. When I wasn't engaged in matters where matters collapsed, for example, or were resolved, I then made myself available to the Deputy Judge President to assist with the civil role. And so during that period, I was kept occupied throughout.
But you can recall finishing 3 criminal trials where you gave judgment.
Yes.
Okay.
Yes, there's 3.
And I see you did 8 weeks in the opposed motion court, as well as 21 weeks in the civil trial courts. But what really stands out is that you've done a solid 8 weeks in the urgent court.
Yes, JP.
Any particular problems on any of those work areas?
Nothing, JP. What I will say is that I particularly enjoy the urgent court. I find that it's a court that requires you to think on your feet. It's a court where you're able to make a real difference if the matter is truly urgent and it's a matter that cries out for judicial intervention.
Yes.
And a number of matters come to mind where I felt that I was able to achieve something for the litigants by being available in the urgent court. So it's a challenge, but it's a welcome challenge.
Yeah. Just turning to your list of judgments, I see 120 judgments, although it could be 121, if one understands the note or the summary you made thereafter, that 120 were delivered within 3 months and 1 was delivered after 3 months, but within 6 months. Would that be correct?
That's correct, JP. The matter that was delivered outside the 3-month period was a judgment of the court.
Yes.
It was a matter, a special allocation. It was a full court matter that related to the application of the Legal Practice Act.
Yes.
And what the requirements were for those persons who'd obtained their LLB degrees before the 1st of November 2018. Yes. So arising out of that special motion were 2 judgments, one relating to the main issue, which was the LPC issue, the second relating to an application that had been made for my recusal by one of the parties, or one of the amici. And so 2 judgments were penned by the court, one relating to the main issue, which was delivered within the 3 months, yes, and the second judgment relating to the recusal, or the refusal of the recusal, which was delivered 4 days outside that period.
Yes. Okay. Thank you very much, Acting Chief Justice. I've got no further questions.
Thank you, Judge President. MEC, let's go through.
Thank you so much, Chief Justice.
Yes.
I have no further questions.
Thank you. You have no questions?
Yes, thanks.
Oh, okay. Okay, thank you. Commissioner Ndolo Lepu.
Thank you, Acting Chief Justice. You must know when I raised the hand, at the first I've got to declare something.
Oh, okay.
I have to declare that Mr. Millar is serving in the LPC Council, and is a specialist in risk and finance.
Yes, okay.
Mr. Millar, I just want you to tell the Commission of all the transformation initiatives that we have been doing, and so far that's basically what the transformative initiatives that we've been doing.
Yes, thank you, Commissioner Dlep, or I'll say Chair, as that's how I normally refer to you. The LPC is really something quite unique, and I think this Commission is probably not aware of the fact that 4 statutory law societies were taken, imploded into one organization, which then became expanded outwards to 9 or 10 separate offices, a national office and 9 provincial offices. And really part of the transformation of the legal profession to bring access to the regulator of the profession to the individual provinces, but also to the people within those provinces, and to ensure easier control of the profession and growth within the profession. Within that context, the current council of the LPC, on which I serve, were then faced with a situation of implementing, basically from scratch, an entire really national organization which would give voice to the initiatives which had been implemented on a piecemeal basis across various organizations and bodies within the country. So that is the background and the context within which the LPC came into existence. We've done a tremendous amount of work. We've, besides the administrative aspects of creating an organization which we believe complies with the imperative of the Act, which is to ensure transformation of practitioners, transformation of the workforce. We've also implemented programs to ensure greater access, for example, for pupil advocates. And one of the things which has been done was to ensure or to secure SACITA grants, so that aspiring advocates who don't come from homes where they're able to be supported are able to access the profession and to then start their journey in the legal profession. Included with that has been the creation of a centralized examination regime. So instead of previously having different bar councils and doing their own thing and setting different standards, we now have a national standard where practitioners, if they're employing juniors to work for them, or clients or other stakeholders, can be assured that there is a minimum standard across the country that has been implemented, and it's a fair standard, and gives voice to ensure that everyone has access to the profession. So those are on the transformation of the profession side of things, which really one can't underestimate. Comes to mind one particular thing which I know was hotly debated, was this question of whether or not prospective employers, could advertise that having a driver's license and a private motor car was a requirement for consideration for employment. And the LPC took the view that that was anti-transformative and gatekeeping, and was really not a correct approach to have, and issued a directive to law firms to let them know that sort of practice was not to be carried out.
Chief Justice, I just want LPC. Yes. I know we have done a lot, but I just want your own personal transformation, especially in your firm, and the mentorship that you have been involved in?
Yes, I personally, most of my candidate attorneys were either ladies or people of color, and that was the team that we built around us. And I'm quite proud to say that everyone that came to my office and I had the opportunity to work with has moved on to bigger and better things. And I think that, for my part, I feel, well, I've assisted someone to move to a level that they might not have moved had they not crossed my path. I mean, the effort is their effort, the hard work is their hard work, and the grit and the determination is theirs. But as with all of us, sometimes just having a friendly shoulder or a mentor to point you in the right direction can be the difference between taking the path that leads you to where you're meant to be, or going along a path that has many more twists and turns than it should necessarily have had. So that has been the approach that's been followed by myself. It was throughout my career, from the very beginning until the present. And it's not.
Try and make your answers brief, Mr. Millar.
Yes, my apologies, Acting Chief Justice. It's 26 or 27 years of a career that where many things have happened, and
Yes.
I was asked once, why didn't you write all these things down as and when they happened? And I regret that I didn't necessarily write everything that I did down.
Yeah,
but
we
it
don't
was
want you to produce whatever you wrote
Yes,
down, covering 26
yes,
years.
no, but what I'm saying is that the things that were done by me and my partner in the firm, and for that, weren't done so that they could be on a spreadsheet to be presented to somebody one day. They were done from the heart, and because it was the right thing to do. And so if I'm a little disjointed in the things I refer to, it's only for that reason, not for anything else. The chair knows well
that's fine.
my character.
That's fine. Are there commissioners on the virtual? Are there commissioners on the virtual platform who have questions? Thank you. Are there?
Yes, thank you, Acting Chief Justice Jenny Kane.
Commissioner Kane? Yeah, okay. Please
Thank
go
you.
ahead.
Thank you. I'd like you to just explain to me, if you're sitting in court and the parties have not pleaded an issue, but in your view, there's an aspect of law which is applicable to the dispute. And you can take it as something new that hasn't been raised in the matter. So it's not actually before you as an issue in the pleadings. What approach would you follow in that circumstance?
Commissioner Kane, good evening.
Good evening.
Yes. It's unusual that may happen, but it can happen, and it does happen that something arises during the conduct of a trial that was not foreseen in the many years of preparation leading up to the trial date. It depends on what the nature of the issue is. If the issue is substantive and there would be prejudice to one or both of the parties, I think the approach to be taken is to alert the parties to the existence of the issue and to afford them an opportunity to make a decision as to what they want to do about the issue. Very often, parties between themselves will agree to either an amendment by consent and then ask for time to prepare heads on the specific issue. It may not necessarily go to the factual matrix that's currently before the court. It may be purely a legal issue. If the issue, on the other hand, requires factual evidence that hasn't been led and may not be readily available, it may require a postponement of the matter. So there are a number of different ways one could deal with it. One would have to look at the specific facts and hear what the parties had to say about it before making a determination.
Thank you. Thank you, ACJ.
Thank you. Commissioner Mpofu.
Thank you, DCJ. Just good evening, Mr. Miller.
Evening, Commissioner Mpofu.
Yes, I just want to give you an opportunity to deal with some of the criticism that you must have seen, which is contained in the GCB submission,
Yes.
which summarized deals with your alleged inability to deal with complex matters. They say you give such matters superficial treatment and don't deal with novel issues well, and even goes as far as to use words like shallow to define how you deal with judgments. Is that justifiable? If it's not, and is it also borne out from your judgments? And if not, can you allay any fears of the commission in that regard?
Yes, thank you, Mr. Mpofu. I don't know who authored the GCB report. My judgments bear my name, and if I'm to be questioned on them, I will answer for them. The report of the GCB has no name. I don't know the author. I don't know if the author was a disgruntled litigant in a matter that was unsuccessful. I don't know the educational qualifications of the person who authored the report. I don't know what their insight is. At the previous interview in April, Ms. Kane pertinently raised a question relating to two of the matters, the Val and Lekwa matter and the Montanari matter. And at the time, I indicated that I accept that neither judgment is a tome, neither is a comprehensive exposition of the law as it could be had I sat back with my feet up and had 3 weeks to ponder the matter. I explained, and I believe this is pertinent, that both were urgent applications, that in the Val and Lekwa matter, there were 2 towns, there were 500,000 people with no water, no electricity, no sewerage, hospitals not functioning, old age homes that had no power. There was no time to sit and write a book for posterity. What was required was a decision and reasons for a decision. And that is what I produced in the Montanari matter. And I did that in 2 days. It was over 600 pages. It was a special urgent allocation. It was over 600 pages of papers for the 2 applications that I had to read. I read them, I listened to the parties, and I delivered judgment 2 days later. It's within a particular context. The Montanari matter involved, the facts are set out, it's a personal matter relating to a mother and a child, and the dissemination of very inappropriate and personal information to all and sundry by someone close to them, and similarly, the rights of the child and the rights of that lady to be spared the humiliation and embarrassment of having their personal communications disseminated, also imperiled me to produce a judgment which set out my decision, but also my reasons. And so I accept that the criticism that, yes, judgments could be longer, but I would say that there's a context, there's the pressure of the work in the division one must take into account, and then there's my own experience. I've spent many years, in fact, my entire career, having to explain to litigants why it takes so long to get to court. And once you get there, why it may take so long to get a decision. Most clients don't really concern themselves with the details, the reasons why. The loser's concerned with the reasons because he wants to know if he can appeal to get the redress he believes he ought to have had. The winner only wants to know that he's succeeded. And so one has to give a reasoned judgment, but one has to balance the rights of the litigants and balance the confidence they will have within the judicial confidence in the judicial system to ensure that they get judgment within a reasonable period of time. Now, having said that, and apologize,
I asked you not to
my
give too long
apologies.
answers, Mr.
If
Miller.
Mr. Mpofu is satisfied with the answer, then
I'm satisfied.
yes, thank you,
Yeah.
Mr. Mpofu.
Okay, President Meyer.
Thank you, ECJ. Good afternoon, Mr.
Good afternoon, President.
Further to the GCB's misgivings just highlighted by Commissioner Mbovu now, there are the two complaints lodged against you, one all the way from Australia by a certain Mr. Bobrov and a local one from Mr. Mokone. What can you tell us about this complaint?
Yes,
Very
President.
briefly, please.
President, in regard to the Mokone complaint, that is a complaint that it was made against every member of the Legal Practice Council. That is an attorney who has been struck off and is aggrieved at the fact that he was struck off. The Legal Practice Council is dealing with it, and it's going to follow its course. They're opposing. He's brought an application, and they are dealing with it. I bear no personal knowledge of Mr. Mokone's matter, and I believe that the complaint against me, as against any other candidate who serves on the Legal Practice Council, was really a shotgun complaint. There's no specific allegation against me, and I bear no knowledge. So that deals with Mokone. I understand that the Commission does have a memorandum from the Legal Practice Council that sets out the facts pertaining to the matter and how the matter developed. In regard to Mr. Bobrov, President, I was asked about this matter at the last hearing, and I did answer. But since then, there has been an important development. On the 4th of May, the Supreme Court of Appeal delivered judgment in a matter, and two things arise from that judgment. One, the Supreme Court of Appeal judgment found that Ronald Bobrov and his son Darren Bobrov had stolen from their clients, stated quite clearly. And two, ordered that they forfeit 95 million rand in stolen money to the state. And so I believe that the courts have spoken on the matter. Mr. Bobrov, for whatever reason, holds me responsible for what has happened to him. I will claim the credit for having started the ball rolling to put an end to what the Supreme Court of Appeal has found his modus operandi was. There is no substance to his complaint, in my respectful submission, and I would urge this Commission to disregard everything that is said by Mr. Bobrov in its entirety.
Chief Justice, can I follow up on that? On Mokone
Yeah.
matter,
Yes.
even I'm implicated because Mr. Mokone wants all of us to be struck off the Legal Practice Council. So
Yes.
it's an issue. No.
Okay, all right. Commissioner Shabangumdar.
Thank you, ACJ. Good evening, Mr. Millar.
Good evening,
Please
Commissioner
speak up a
Shabang.
bit.
ACJ, I don't have a question for Mr. Millar. I just want to declare that I know him. We spent many years together at the LSNP as councillors.
Okay, no, that's fine. I think we have come, Commissioner Matonsela.
Yes, thank you, and good evening, Mr. Millar.
Good evening.
Is it true that you're a member of the Black Lawyers Association?
I was a member of the Black Lawyers Association until 2015, and then I had to stand down my membership. In the interest of time, I can explain the circumstances to you, but it was in order to facilitate an election that hadn't taken place for 20 years within the legal profession. In a nutshell, the transformation initiative of having BLA, NADEL, together with so-called statutory members, was then used as a mechanism to prevent an election of the statutory members. And so anyone who was a member of BLA or NADEL couldn't call for an election or stand for election. So with the concurrence of my then president of the BLA, Mr. Mabunda, it was agreed that I would stand down so that I could do what I'd intended to do. And that is what happened.
Thank you.
Acting Chief Justice, may I ask a question, please? It's Glenys Breitenbach.
Yes, please go ahead.
Thank you. I'm not switching on my camera because there's a lot of wind and I'm worried that I have a bad signal.
Okay, all right.
Good evening, Mr. Millar.
Good evening, Commissioner Breitenbach.
How are you?
I'm keeping well, thank you, and yourself?
I'm well, thank you. I asked you this the last time and I'll ask it again, since it's been raised again. Mr. Bobrov is currently in Australia.
That's correct. And if he's got anything to say, he must come back and say it here in South Africa.
Yeah. Yes, if he wants to malign you, let him come here and do it. Instead of hiding under a rock in Australia, evading justice, the cheek of it is quite breathtaking. Thank you, Acting Chief Justice.
Thank you. We have come to the end of this interview. Thank you once again, Mr. Millar, for availing yourself. You are now excused.
Thank you, Acting Chief Justice. Thank you, members of the Commission, for the opportunity to appear before you.
Thank you.